This video provides information for Court Assistance Office petition forms involving custody of a minor child or children. The Court Assistance Office provides forms and legal information, but not legal advice. By using these forms, you will be representing yourself in court. Sometimes cases are complicated, and instructions in the forms are not a substitute for legal advice. The laws and court rules are complex, and following these instructions will not guarantee you a favorable result. You may need to consult with an attorney in order to move forward with your case. When you are petitioning the courts for a custody order involving minor children, your petition will communicate to the court and to the other party what you are asking for regarding the following subjects. First, custody, both legal and physical, will be addressed. In the next slide, we'll go over what each of these specifically mean. Next, you will outline what you are asking for regarding visitation. This will be carefully detailed in your parenting plan. By referencing your parenting plan in the petition and attaching it as Exhibit A, it then becomes part of your petition. Finally, child support will be addressed in your petition. Child support is mandated by the state of Idaho. You are required to submit accurate calculations based on the Idaho Child Support Guidelines. The overnight visitation schedule set forth in your parenting plan is your verification to the courts that child support has been calculated correctly. There are two types of custody in Idaho. Legal custody refers to the right and responsibility to make decisions about health, education, and general welfare of the children. This refers to who will be making the day-to-day decisions that involve the children. Physical custody is the right and responsibility to spend time with and provide care for the children. This refers to where the children will physically be. Idaho law presumes that it is in the best interest of the child for both parents to have joint legal and physical custody. The word joint does not mean equal or 50-50. It simply means that both parents jointly share the rights and responsibilities with regards to the children. The custody percentage calculation will actually be calculated based on the number of overnights each parent has with the children, and this will be verified by the schedule set forth in your parenting plan. Sole custody will only be awarded in limited circumstances. You should consult with an attorney if you believe sole custody is best for your child. Sole custody is not granted to one parent based upon failure of the other parent to pay child support or based solely on the other parent's amount of involvement with the children. Sole custody may be awarded temporarily or until the other parent is able to comply with court orders or treatment programs. Once again, if you ask the judge for a sole custody order, you are asking the judge to allow you to control what, if any, contact the other parent has with your children. You will need to be prepared to prove why it is in the best interest of the children for one party to be awarded sole custody. If this is how you want to proceed, we strongly recommend you visit with an attorney before filing for sole custody. Let's take a look at the actual petition. Now is a good time to pause this video, grab your petition, and turn to the paragraphs that address custody. It will look like this. First, you will choose the option you want regarding legal custody. Option 1 is to award joint legal custody to both parties. The second option given is to ask that one party be awarded sole custody and then to state your reasons why. After you have finished filling out the legal custody section, you will move on to the physical custody section. Again, the first option you have is to award joint physical custody to both parties, but this time it says, on the terms and as described in the parenting plan attached as Exhibit A. This is the place in your petition where you will reference the parenting plan as an exhibit, and then it will become part of the petition. You also have an alternate option here. Instead of asking for joint physical custody, you can ask that one party be awarded sole physical custody, and then you would continue to state your reasons why. If you are considering asking for sole custody, we strongly recommend you visit with an attorney before filing. There are some attorney resources available to you that you will want to know about. First, the Idaho State Bar has a lawyer referral service. You can contact the Idaho State Bar online and sign up to speak with an attorney in your area that practices the type of law that you need that will give you a half-an-hour consultation at no cost. You pay the referral service $35 and then you talk to the attorney for half an hour. Next, your local county may host a free attorney clinic where you can go in and speak with an attorney and ask questions at no cost to you. Please check with your local court assistance office to find out more information.